Hey everyone, this is Brian Festa, Vice President and co-founder of We the Patriots USA, also author of the We the Patriots USA Substack free blog. I decided to do a video today because I've got a lot to unpack. It'll probably be quicker for me just to explain it and show you some things that probably quicker for you to actually digest it all as well, as opposed to reading through a Substack and going to all these various links that I'll have embedded, share my screen, show you some things. I want to talk today about the issue of MAHA, whether MAHA. I'm hearing a lot of questions about some things that happened in the last weeks, last month or so, at the government, and whether or not those things are what we voted for. Junior services. A lot of things happening. A lot of people are getting messaging that they didn't really expect this administration regarding vaccines, health freedom, even religious liberty. So I want to talk about three things in particular. First is a letter from RFK Jr. to Congressman Greg Steube, issued on May 4th, 2026. The second is a brief filed by the U.S. Solicitor General in a case that's currently pending for the Supreme Court. Supreme Court review regarding the New York healthcare workers' COVID mandate, loosely there, from 2021. Believe it or not, that's just now petition for the Supreme Court. Third executive order that was issued by President Trump a few days ago on May 29th, regarding the CDC's childhood vaccine. Let's jump right into it. Share my screen. I'm going to start by talking about that letter from RFK Jr. to Congressman Steube. Congressman Steube is trying to get the to pay some attention to what's been going on at the federal level with regard, or at the state level, excuse me, with regard to vaccine injections, religious liberty, how the state, unfortunately, many states like California, New York, Connecticut, Maine, West Virginia have not been respecting religious liberty. And that's a big problem, folks, because the First Amendment guarantees us religious liberty, doesn't it? So let's see if I can go this up so you can see it. All right, so this is the letter to Congressman Steube from RFK Jr. And it says, your letter concerns parents who have sincerely held objections to vaccination mandates. You note that states without exemptions from vaccination requirements, parents and families who object to vaccination are compelled to violate their faith. You request the Trump administration to take measures, including issuing an executive order, to ensure the protection of civil and religious liberties regarding vaccines. Talks about hosting vaccine recommendations, and then the department does not have the authority to issue nationwide vaccine requirements for the public, nor does it set or enforce state requirements for school attendance. The department actively engaged in protecting the rights of vaccination under our existing limited authorities. Parental rights and rights and religious liberty seriously. Questions about exemptions, accommodations, and enforcement are generally addressed under the legal framework of the jurisdiction. Talks about the letter that HHS issued back in September of last year that notified vaccines for children program state employees money that's given to states for that program, for immunization programs, how they respect state religious conscious exemptions from vaccine mandates, and talks about one particular investigation that was here open into a Midwestern school called child eventually provided wishes, ignoring religious exemptions to the state law, requirements. Your colleague letter was also issued law requirement to provide counter access to this information. These are all great things, but you notice it doesn't talk about specifically the states where religious exemptions for school vaccinations are still currently prohibited. It's not to say that really it's not the role of HHS. We can't override state law. We can't, the 10th Amendment says if authority has not, powers not specifically granted by the Constitution to Congress are reserved to the people. It's not granted specifically to the federal government, it's reserved to the states or to the people respectively. So there's nothing in the Constitution specifically about obviously school vaccination requirements. There is something about liberty in the First Amendment. And this letter, of course, leaves open the question whether they're violating the First Amendment. He's saying, basically, in my interpretation of this letter is we don't really have the power to act directly and unilaterally. If they're violating the Constitution, it doesn't say this, but I mean, the supposition here, the implication is that's not our job. You have to take that, right? If they're violating the Constitution, it's the court's role, particularly at the highest level, the U.S. Supreme Court's role, to strike down a law that violates the U.S. Constitution. It's not something HHS do unilaterally. Even if they were to do it unilaterally, and this is something that we're thinking a couple times today, at least, if they were to do that, it would be challenged in court. Likely, HHS would lose, the Trump administration would lose, and even if they didn't, it would be undone as soon as a new president came in and disagreed with President Trump. And so it would be a very short-lived victory. It would last possibly maybe the next 2 years, less, and that would be it. So, we're going to use 2.5 years, whatever it is, until the president being elected. So it's not, there's not much HHS can do. I don't necessarily disagree with Secretary Kennedy. Legally speaking, he's an attorney, obviously, very well trained, highly respected, very experienced attorney. His legal interpretation, in my opinion, is correct. As much as it's frustrating to everyone out there to hear this, HHS does not have unilateral authority to override state law, to tell states they can't pass certain laws, to threaten them or whatever else. Even withhold funds, the president's already said that some funding can be withheld if religious liberty is respected. That's what that BCP letter was regarding, but that really hasn't done much to stop these states. Again, all of that can be challenged in court, and it can be a long, protracted legal battle that could potentially last until the president's not even in office. So, now what people wanted to hear, a lot of people are very upset about this, but legally speaking, the 10th Amendment does prohibit federal government agencies from really marching into states and usurping state law. And that's something that we should all be happy about. That we have a federal government and the power to states. Otherwise, especially for those of you living in so-called free states or red states, where religious liberty is highly respected, widely available religious exemptions and even conscious personal belief exemptions to school vaccination requirements. He could have come right in, or the next person could come in and completely override the state law. Say, no, you're not going to respect this. You're not going to do that. You're not going to allow this. We don't want that, right? We don't want. We do not want the federal government agencies to be able to come into a state and say, no, your state law is valid. You can't force that state law, or we're going to take you over, punish you, or something like that. We don't have monarchy. Okay? We don't want it. So as frustrating as it is, that Secretary Kennedy and President Trump can't do more with respect to religious exemptions. That is how our Constitution is set up. That is how our federal government is, constructed. That's just how the framers set it up, and we should all be happy with that. The next thing that I said I was going to address is the brief from the U.S. Solicitor General, and that brief came out just 2 weeks ago, maybe about a week ago. And I'm sure I screened this one too. Before I get this was the New York healthcare workers mandate case. One of them. We had one of them, which is actually heavily discussed in the Solicitor General's brief. It was a decision we were not happy with, we did not agree with. We still stand by that. Obviously, we appealed to the U.S. Supreme Court. We were one justice away from getting it taken up back in 2021. Illegal Thomas Gorsuch would have taken it up. We couldn't get just one more justice. We need four to grant review the case. We couldn't get that final fourth justice to agree to take it up. Fortunately, we did not get our case reviewed, but we were very, very close. And we're going to keep fighting. We have other cases in the pipeline. One in particular, which is really close right now. Well, but unfortunately, that was a bad decision. We think the wrong came from the Second Circuit for New York healthcare workers. We brought to the Second Circuit one, Section 2.61 was the New York healthcare workers mandate for the COVID-19 mandate, COVID shot that required all healthcare workers to get COVID-19 shot, but did not allow for religious exemptions. Didn't say they couldn't have any kind of religious accommodation. That's in this brief. So the Supreme Court, in this case, withdraw the Supreme Court actually asked the U.S. government, Solicitor General, to weigh in on this. Should we review this case? Should we review this challenge to the New York healthcare workers mandate, this decision that came from the Second Circuit? Should we review it? Should it take it? And believe it or not, the U.S. government let that stand. That was a shock. Aaron Siri tweeted about this. Everyone from Aaron Siri to Thomas Matthews tweeting about this about a week ago. Very upset that the government had, in essence, it was the sentiment. Let me actually share that with you. I'll show you the tweet. He says the Trump administration just filed a brief in the U.S. Supreme Court betraying religious liberty by arguing it's perfectly fine for employers to have policies that allow medical but not religious exemptions. And he clarifies here a bit more detail. The administration explaining that petitioners are former healthcare workers who contend that New York's now repealed COVID-19 vaccine mandate healthcare workers, Section 2.61, because foreclosed employers from granting any reasonable accommodations for religious practice, and that Section 261 permitted only a medical exemption, did not include a religious exemption. Instead, I'll skip down. Instead of defending these wrongfully terminated workers, DOJ unsuccessfully and shamefully plays word games to characterize the request as taking an exemption, which New York law prohibited, instead of an accommodation, an option federal law requires. It then relies on this semantic nonsense to argue that the Supreme Court should not review the Second Circuit's holding that policy providing for medical but not religious exemptions is legal. I want to dive into that. So sharing this now, I'm going to share my screen with showing brief. Here's the brief filed by the Solicitor General in this case. From the top, you can see it, John Doe versus Kathy Hochul, Governor of New York, and it's filed by the Solicitor General and others. The question presented whether a state law that allows for reasonable accommodation short of complete religious exemption is consistent with Title and therefore can form the basis of effects. Let me just explain to you what is Title is the federal law. Is the federal law that allows for that prohibits discrimination in the workplace. not just religious discrimination, any kind of discrimination. Religious discrimination is what's at issue here. Any kind of discrimination that's based on class, race discrimination, color, national origin, so forth. Religion is one of the protected classes, though, and clearly prohibits religious discrimination in the workplace. So it's federal law. We're not talking about this is a challenge based on saying that the employer that what Solicitor General says here is that if the state law conflicted directly with federal law, it would be preempted. So if federal law preempted state law here, then the employers could not claim that the hospitals, for instance, that employ these healthcare workers, they were claiming that it would be an undue hardship. They violated the law here. They violated Section 2.61, then they would be subject to fines, and that would be an undue burden, undue hardship. And so that's not an excuse. Solicitor General said, well, if it's preempted, that's not an excuse. Okay, if there's direct conflict in state law and federal law, like for instance, if the state law, Section 2.61 said no religious exemptions whatsoever are allowed, no religious accommodations are allowed. You can't grant a religious accommodation for any healthcare worker. Those are precluded. If that was the law that was completely precluded and you weren't allowed to allow any kind of exemption, then yes, they're saying that that would be a conflict. And in that case, the defendants, the employers, can't just use that excuse. Well, oh, okay, so we're not going to. I just took that off for a moment. Showing anything on there. Then you can't use that as an excuse, okay? That it would be too much of a burden because it's preempted in federal law. In this case, they're saying it wasn't preempted. Why? Because state law technically was just silent. It was sneaky how they did it. They didn't say you could not grant any kind of religious. They just said medical exemptions are going to be allowed. They didn't say they just said this is the only exemption that's allowed. They said medical exemption. They didn't really say anything about the religious exemption or any other kind of religious accommodation. So in this brief, the Solicitor General explained that, well, you could have, that's not quite accurate because they could have allowed, they could have allowed some other kind of religious accommodation, blanket exemption, which is only exemption requested. And it is true that under Title VII law, legal case precedent, the employer does not have to grant the requested accommodation. So if your only request is that you want to be exempted from the shop, that's the only thing that will accommodate your religious belief, that's something you'll accept. The employer isn't forced to grant that. They can grant some other reasonable accommodation for your religious belief. So in this, Solicitor General use the example of telemedicine. So for some of these healthcare workers, they could have requested telemedicine. Now, for an ER nurse, no, telemedicine is going to work. But a lot of these healthcare workers were not ER nurses or doctors. They were other personnel that worked in the hospital that technically could do telehealth or could be reassigned temporarily to some other job. So the Solicitor General says, well, why did they request that? Why did they amend their complaint to explain that illusory that the employer never would have granted because there's evidence here that they were not granting any accommodation for religious beliefs, regardless of whether it's not just a request to be exempted from receiving the shot, blanket request, but they weren't even allowing these. So perhaps it's true that the petitioners in this case could have argued it better, could have amended their appeal. I'm not criticizing the legal work of the attorneys or anything like that, because I don't know the whole history here or all of that. I'm just saying perhaps it could be true, and that's the argument they made, is that pled enough, that there are other things that the petitioners could have done, other accommodations that could have been provided, and since state law didn't preclude those, because if you look, and I'm going to push back a little bit with respect to what our series said, that's these things just accommodation. Not really. I practiced civil rights law for years. I was the belly of the beast, so to speak. I worked for a state government civil rights commission, and I lived and breathed it. So all I did was prosecute, investigate, mediate cases of employment discrimination, housing discrimination, disability discrimination, public accommodation discrimination. A lot of it was employment, or the bulk was employment discrimination cases, and it is it's true that you do not have to provide, the employer is not required in Title 7 to provide the requested accommodation, just simply some accommodation that's reasonable and won't pose an undue hardship to the employer. Also, religious exemption from the shot isn't the only possible accommodation in every case. Sometimes during COVID, we saw masking and testing. Not that I'm a fan of those things, but those were an alternative. There were some employees that were allowed to keep their jobs, not get shot, just do masking and testing. There were other employees that were allowed to work remotely or do, in this case, healthcare workers telling them in certain states they were allowed to do that. In New York, apparently, so much more to understand, but in other places they were. So there are other kinds of religious accommodations that still allow you to be accommodated under Title 7, but don't mean just a blanket exemption from shot with nothing else. Basically what the Solicitor General is saying, these employees just said, no, we want to continue to come to work as we always have. Work in the hospital, in the clinics, in the doctor's office, but just not receive the shot. That's what we're not asking for anything else, we're not accepting. That's what it appears that's what they were asking for, is just to be exempted and very unusual. I find it hard to believe, because I spoke to a ton of employees during COVID, that they wouldn't have accepted another accommodation. They wouldn't have accepted perhaps or temporary role at the same day. It doesn't require a shot. Pretty much every employee I spoke to would have accepted. So I do think this is kind of, in some ways, there is some wordplay going on here because, all right, maybe that wasn't led explicitly below in the filing, but we know the reality of it is that the employers were not. Hospitals were not. They were saying, you get the shot. But technically, the way it's led, there's an out there for it, okay? That it wasn't a direct conflict, and because there's not a direct conflict in state law, federal law, that they can, in that case, use the excuse that we're going to do hardships with fine, sanctioned, or other penalties by the state. That's the only time you can do it, when there's not a direct conflict. So that's why I spent so much time in this brief talking about direct conflict in state law and federal law, because if there's a direct conflict and federal law preempts state law, then the employer can't get away with it just by saying, they don't get a pass. They can't say, well, because we would have been forced to violate state law or state regulation, then I'm using the regulations law to change it. It's important to see that regulations enforce effective laws, how courts interpret regulations. So that's why I'm kind of using interchangeably. Some of you might push back because it wasn't really law, order from the health department. Well, it's kind of seen the same way, in the legal analysis report. Okay. So anyway, if it were entirely preempted, then they wouldn't be able to get a free pass. Hardship. But because it was not preempted, there technically were still other accommodations that would have been allowed in 2.6. Then it's not preempted, then they can use it. Therefore, they say, and also because they're saying the Supreme Court shouldn't bother, shouldn't take it, shouldn't have. And so the Trump administration, the DOJ, actually is advocating for the Supreme Court not to review this. I think that's a very poor position, even if they're legally correct about Title 7 preemption, which I do believe they are. Yes, someone practiced it for years. I do believe they're actually legally correct. It doesn't mean that the decisions that they cite, including the major decision, should not be reviewed. And there's other reasons they should be reviewed. And that's what I would say that I would point that. Okay, so maybe they're right that it's not preempted and that it possibly could have posed an undue hardship, but there's other reasons it should be reviewed because the case law they're relying upon is flawed case law. And the Solicitor General relies upon not only our decision, but other challenges that were brought to the New York Healthcare Worker Mandate and other decisions. And they're saying, well, those are the decisions, so, this court had to follow it. This just, it's the law in that circuit. It should be respected. No, we list several reasons why I believe those decisions, we feel very strongly those decisions were incorrect, should be reviewed. And this is a chance, and that's was passed. The Supreme Court still might take it up, but now this is another obstacle. The Supreme Court obviously very seriously considers, very carefully considers the position of the U.S. government. And even requested in this case, the U.S. government to weigh in. The U.S. government saying should review it. That could heavily influence the decision of justice, and they may not say anything wrong, but there's still a chance. But unfortunately, this doesn't weigh in favor of taking it up. So that was another disappointment. People said, "Oh, what are you doing now, Trump administration? Now you're letting us down once again on some sort of legal technicality, not to review a COVID mandate for healthcare workers, not to review and to create really good law. The Supreme Court to take that back because of legal technicality. I can understand why people are frustrated by it. And then the third thing I want to discuss, partly after 26 minutes, so much for getting this done in 10 or 15 minutes, but there's a lot to unpack here, is the executive order that came out just so I'm going to share my screen there as well. Here it is. See that? Realigning United States core childhood vaccine recommendations with best practices from peer developed countries. So we talked, we heard this coming out from CDC and ACIP a few months ago, earlier this year, that they changed the childhood vaccine schedule to eliminate requirements, certain vaccines that had previously been required for routine childhood administration. They moved them to align with, for instance, Denmark. Germany was one of the countries. Sweden might have been in there. And so there were several developed countries they looked at and said we should do things more like them. They're not seeing an increase in adverse health outcomes with a decreased vaccine schedule, so we should decrease ours as well. They looked at studies, safety studies, and so on and so forth. And so it talks about that. It talks about European nations in particular. The consensus is that we should not have as many shots given as these children. That's all great. That's wonderful. And it's directing the CDC and ACIP, which is the Advisory Committee on Immunization Practices. They're the committee that makes recommendations to the CDC, which generally do get adopted by the CDC regarding the childhood schedule. ACIP's review should consider ways to provide maximum flexibility to parents and doctors through recommendations for timing and sequencing of the administration of routine immunizations. Here's the really important part that I want to point out. Each executive department and agency shall ensure all actions, regulations, funding, and coverage related to childhood and adolescent immunizations align with the schedule recommended by the ACIP and adopted by the CDC, including fulfilling all legal obligations with respect to parental authority, religious freedom, disability accommodations, and equal protection under the law. That's one. Sounds great, right? Sure does. And I agree with it. I usually with that at all. I don't think any of you listening really do. One thing I am hearing pushback on is that we talk about states that federal executive department agency. The recommendations should and it should align with the schedule recommended by the ACIP and fulfill all legal obligations. Okay, so federal agencies have to respect freedom, disability, accommodations, protection. What about state governments that don't allow religious exemptions to school children? this is still not addressing that. This is still just talking about a federal level, but allowing those state laws to stand. Those state laws, which I feel very strongly, I believe very strongly, conflict with and violate the First Amendment. Free exercise of religion falls in the First Amendment. What about those state laws? It's silent. Just talk. Why? Well, because once again, the federal government does not have the power to issue executive orders that basically nullify state law. The federal government does not have the authority to issue an executive order for certain states and says states are not must all allow their exceptions. If President Trump did issue such an executive order that said that, which is what people want, people are waiting for him to do that. People have been asking to do that. If President Trump were to do that, immediately all the attorneys general in states like California, Illinois, Connecticut, New York, Maine, Massachusetts, New Jersey, the list goes on and on and on and on and on. They would all get together, file a legal challenge or a series of legal challenges, and very swiftly, I believe, the district court was striking down, issue an injunction and stay. I believe, sadly, to the dismay of many out there, the Supreme Court would uphold that injunction, would strike down. That's a constitutional violation. The Constitution does not give the president unilateral authority to issue an order that state laws are null and void. State laws cannot be respected, and that you can't strike down with a stroke of pen state laws. They'd be nullifying all those state laws, so you can't have this basically striking state laws is hereby banned. It's hereby repealed. The president doesn't have the authority to do this. If state laws don't be struck down, have to be done by, once again, the courts. Courts have the sole authority to strike down laws. So here we find ourselves again in the same place where we started. What I've been saying for the last 6 years, since this organization came to be, and since we started filing lawsuits, litigation is the way we win. Do we win every battle? No. Does it take a long time? Yes. Is it as fun? Is it as exciting as presidential election or executive order? Is it as quick? No. But it's the process that we have to challenge law. It's the only process that really works and actually is the and this is why it's so important that we're asking you, please support Mission 250. Yes, I am going to plug in here at the end, because the only way we can do that legal work is with your support. Without your support, without the necessary funds, we stop all of this, and there's no more challenges. We will not be able to bring any more challenges in defense of religious freedom, health freedom, parental rights, free speech, and so on and so forth. All the work we do is contingent on funding. So we are trying to raise $250,000 by our nation's 250th birthday, July 4th, 2026. We sent out some mailers last week. You may have received one in the mail. We also made posts about it. We sent emails about it. We'll continue to do so, leading right up to that July 4th deadline. But we really need your support. Even if it's only a very small gift. You know, we're asking for increments of $2.50, so $2.50, $25, $250, $2,500, and so on and so forth. Whatever you can give. Go online right now, legalpaymentsusa.org. You can see the Mission 250 graphic right there on the homepage. Scroll down a little bit, you'll see it. Click on that, click the button, or the button says support our work, our mission. And you make a donation there. You can also mail us a check to the address at the bottom of the website. Please, we're relying on your support. We have legal challenges aimed at restoring the religious exemption for school children in Connecticut, in California. We have one about to be filed in Maine. So that would cover all three circuits. The United States is divided into different circuits that have jurisdiction over groups of states or regions. And the three circuits that currently have banned religious exemption for school children. Second, first, We will now have named lawsuits in all three jurisdictions trying to aim at strong school children. If certain courts don't rule in our favor, we intend to file appeals from all three of those circuits to the United States Supreme Court. So there's 3 more bites. Closer than then. I do believe it's going to happen very, very soon. A lot of work over these last 6 years to get to this point. Litigation is expensive, lengthy business, it's slow business. But I believe it's something that's staying power. Executive orders, even if they were allowed to stand, you end up with the next president. So, already during this broadcast, even if you were allowed to do it, and the Supreme Court did allow it, it would just be repealed, and it would be repealed by the next president who comes in and disagrees. So, what's the value of that? Yeah, maybe 2 or 3 years of freedom, and you lose again, but start all over again in the courts. Oh, by the way, in the meantime, that we're allowed to have all those state laws were nullified, and all the children were allowed in the next 2 years. All the lawsuits that we've had, that we've been working on for the past 5 or 6 years, will all be dismissed. This court would say, well, children are in school now. Dismissed, case dismissed. So then, when the new president comes in, we have to start all over again. Now we have another 5 or 6 years of litigation. You see why I'm not very supportive of going the executive order route? I don't want to start all over again. That's a lot of donor money that we've spent litigating in court to win these victories. I don't want that all to be wasted. We're so close right now to getting the Supreme Court to take these out. And of course, we just had the Solicitor General step in. It's very, very frustrating. Naturally, you know, that was for workplace discrimination. That's not for school vaccine exemption. So, we literally just had the U.S. government, Trump administration, say, don't do. So, is there reason to be disappointed with MAHA? Yes, but not to the extent that some people think. Just to be fair, there's nothing legally incorrect about anything, either the letter from RFK Jr., the brief filed by or the executive. Legally, there's nothing incorrect. Everything they said they was legally correct. It's not what people want to hear, though. What I've discovered in this business more than anything is that if you tell people what they want, they like you. They will fund you. I've seen people raise millions of dollars by telling people what they want to hear. That's not always true. What people want to hear and what the truth, what the facts are, is very often different. I've always gone with the default that we're going to tell the truth. That is the only, not just the default, that's the overarching rule. We're going to tell the truth, regardless of whether it hurts us or not, even if it hurts our bottom line. Because yes, I have a fiscal responsibility to raise as much funds as I can, but I also have a responsibility to do that ethically, to do that legally, moral responsibility to God. To tell the truth. That's hurt us. We've lost potentially millions of dollars by refusing to get in that camp and say, hey, give us a donation, we're going to get the federal government's executive order, or we're going to get the DOJ to prosecute vouchers. So we knew those things weren't happening. And I got on podcasts and I told people over and over again, those things aren't going to happen. The way to go is litigation. People didn't want to hear it because it wasn't quick, it wasn't easy, it wasn't sexy. People didn't want to hear it. People got upset. And they left our camp and went over to the people that were telling them. That's human nature. People like people to tell them. But we will never, ever tell you what you want to hear if that isn't the truth. If telling you that would be false, we're not going to do it. Don and I, this president, we paid this both on. Don and I have been very, very strict. We'll always tell the truth, even if it hurts our body. So, please help us. You see, if you look at our, you can go back and look at the articles I've written over the years, the emails I've sent, podcasts. You'll see I've consistently said this was not trying to win this through a presidential election. You have to respect the work people are doing. We're trying to do that because their hearts are in the right place, and there are some gains that can be done at the federal level. Not everything. Not every door is foreclosed and not opening. There are some paths to victories, other paths to victories. And having effective change, the CDC vaccine schedule is very, very important. Having all this votes, having doctors at ACIP and tell the truth for once about the safety studies and the lack thereof for vaccines. It's extraordinarily valuable. It gets all that information out in the public sphere, even if it's not done. So I think a lot of the work that's been done at the federal level is great. It is very valuable. So I don't want to discount the efforts of any organizations or individuals working to I'm not saying it's useless. I'm just saying with regard to school districts in particular, I don't think it's the right path. I think litigate is right. I've always said. But that doesn't get you a lot of steam, a lot of runway in this business. people forget very quickly. They don't remember that I was there 5 years ago, say, and 4 years ago, 3 years ago, 2 years ago, last year. For whatever reason, they still are donating massive amounts of money to people that are telling them what they want to hear, but that hasn't been true. We have seen legal victories. Look at the legal victories for COVID mandates, for employees in particular, 2 or 3 years in the courts. Massive legal victories for employees who were fired for refusing COVID shot religious grounds. There have been massive legal victories. That's where we've seen the victories. And legal victories stand. If a federal court, or especially the Supreme Court, issues a decision in favor of religious liberty or health freedom, that's going to stay most likely for decades. Talk about staying power. It'll be here long after you're gone, your grandkids. That's how effective legal. Yes, it takes longer to win, but when you win a legal victory, it stays around a lot. That's all I'll say here. I've been on here for over 40 minutes. Way longer than I wanted to go today. I think it's important to get information out there. Please, again, consider supporting this gift. The mission to FDA, leadingpatriots.org. Until next time, God bless. And I wish you all the best, health, happiness,